Hello, friends. Welcome to Unacademy. This is me, Dr. Sidharth Arora.
So, friends, we are continuing with our series Understand the World with Dr. Sidharth Arora. And today, I'm sure you've read this news. This news is all around the social media. You open the television channel right now, it is all a buzz. A buzz with that the Uttarakhand Legislative Assembly has finally taken the step to introduce or rather propose the Uniform Civil Code Bill, which is called as the Uniform Civil Code for the State of Uttarakhand 2024 Bill, the Saman Nagrik Sanhita, which shall be applicable if passed by the State Legislative Assembly in the state of Uttarakhand. Big news, and I say big in capital bold letters. It is big news because the media was waiting, legal pundits were waiting, the political circles were waiting whether this is going to happen or not. Ultimately, this has happened. The Chief Minister of Uttarakhand, Mr. Pushkar Singh Dhami, has tabled this bill in the State Legislative Assembly. Of course, the days ahead will also explain to us, or rather show, what are the modifications to this bill. Is it going to pass or is it not going to pass? All of that, of course, in the future, we as students of law are only going to study what is in this bill. So let us study this. Let us understand this. Of course, it's very, very important as a concerned Indian citizen as well as a civil service aspirant, because this is going to be a very important topic. So, without much ado, let's continue with this part. So, before I start, all those who do not know me, I'm Dr. Sidharth Arora. I'm a practicing advocate in the Supreme Court of India. On Unacademy, I've been teaching polity, governance, and international relations to civil service aspirants as well as PSI optional. I've been blessed by the love and the respect of our thousands and millions of learners who watched me on the Unacademy platform for 30 crore plus live minutes. And there are 266,000 plus followers and thousands dedications, and I'm thankful for every one of them. I hope to be of use to you, continue to provide you with better education, better guidance for you to be able to fulfill your dreams and aspirations. My code, as referred, is SIDLIVE, SIDLIVE. Kindly use it whenever you are taking the subscription of Unacademy for any of your preparation. SIDLIVE, SIDLIVE is my referral code. So this is the news that we are discussing. It says Chief Minister Dhami tabled the Uniform Civil Code Uttarakhand 2024 bill in the State Assembly in Dehradun. Now, this bill has been tabled. What are the changes proposed? We should know that. What are the future challenges that this bill is going to face? Even if it is passed, that is something that we have to study. And also we have to study the historical perspectives and the philosophy behind Uniform Civil Code. Let's take it step by step. Make sure that you watch this video till the end. Also share and subscribe and let everyone know, because this is not only important as a lawyer, this is not only important as a civil service aspirant. Every Indian should know about what is happening over here. So, let's try and understand how did Uttarakhand government actually go about its matter. First of all, there was immense amount of deliberation, discussion, public participation before this bill came into place. So a government appointed panel was made. It was led by Justice Ranjana Prakash Desai. A big piece of report came with several recommendations. If you look at the screen, an appeal was also made to the general public. They were asked for their participation, they were asked for their opinions, because Uniform Civil Code is going to affect each one of us. So people were allowed to make online representations, many papers were done, many feedbacks were given, and then finally the committee gave certain recommendations on the basis of which this bill was drafted. So in a way, I congratulate the Uttarakhand government that it was not a knee-jerk legislation. They did their job, they went about their job very nicely, very professionally, and very much like a democratic government should do. So, this is how the process happened. Now, if I quote the government of Uttarakhand, they say Uniform Civil Code, and I quote, for the good of all sections, unquote, and also aligned with Prime Minister Narendra Modi's vision of, I quote again, Sabka Saath, Sabka Vikas, unquote, and quote again, Ek Bharat, Shreshth Bharat, unquote. In other words, Uniform Civil Code has been placed in a position that it will create national harmony, it will create uniformity of law, it will remove any kind of possible injustice in the name of personal laws, as has been alleged in the past. So, Uniform Civil Code has got a huge history. So, first of all, understand that Uniform Civil Code has a huge history. So, for the uninitiated, this is a promise, this was a direction. This direction was given by the founding fathers of the Constitution or the Constitution of India and is placed in Part 4 of the Constitution. Part 4 of the Constitution deals with directive principles of the state policy. We are specifically talking about Article 44. Article 44 provides that the state shall endeavor to enforce a uniform civil code throughout the territory of India. This is the promise. Now, one may wonder why it was not enforced right at the commencement of the Constitution of India and instead placed in Article 44, which is a part of Directive Principles of the State Policy, putting the onus upon the future governments to enforce Uniform Civil Code if and when possible. The reason to this, in the easiest possible ways, is, in my opinion, that at that time, at the time of 26 January 1950, that is on the commencement of the Constitution, India had a very strong communal, volatile environment. Of course, the partition was very recent, occurring at that time. 15 lakh, can you believe? 1.5 million men, women had been slaughtered in the name of the so-called partition. It was not a partition, it was a bloody civil war that India faced. The founding fathers and the government at that time, the powers to be, must have thought that the environment is so volatile, we should not touch Uniform Civil Code, any concept like this, because Uniform Civil Code, at least in my opinion, is not only a piece of legislation. It deals with what are called as personal laws. The unification or making the same uniform personal laws is the aim of Uniform Civil Code. Personal laws are different for different religion. For example, you have the Hindu laws, you have the Shariat laws, you have the Parsi laws, you have the Buddhist laws, the Jain laws, you have so many schools, the Sikh laws. So it might have been weighing heavy on the mind of the governments at that time that we should not touch this, because inextricably the personal laws are linked with the concept of faith. This would probably the very basic reason why Uniform Civil Code was placed in Part 4 of the Constitution in Article 44 and not enforced right on the day of commencement of the Constitution. But then happened what is called as absolute political apathy. The earlier governments did not even think, they did not even attempt to enforce anything called Uniform Civil Code. If at all there were attempts, it was actually just formal dilly-dallying with the Law Commission recommendations. Law Commission recommendations whether or not should we have Uniform Civil Code or not. The Honorable Supreme Court in several judgments, especially after the much infamous, or rather famous as you would like to see, the Shah Bano case, the Muhammad Ahmad Khan was the Shah Bano case. The Honorable Supreme Court has many a times directed the government that the time has come that in this country, when there are codified criminal laws, when there are codified civil laws, when there is uniformity of every other law, why should we not have a uniform personal law or a uniform civil code? Goa as a state has already experimented with this successfully. Why not the rest of the states? There has been opposition to this school of thought also. The opposition was that if you create a uniform civil code, that might adversely affect the concept of pluralism and diversity in India. We have to entertain both the opinions. You can subscribe to any of the point of views this way or that way. Finally, the government has taken a call, at least in the state of Uttarakhand, they have taken this call that they will go ahead with the Uniform Civil Code. This is also a way of testing the waters. And I congratulate the present Narendra Modi government that they have decided to first test the waters in the state of Uttarakhand to see how this Uniform Civil Code pans out, at least in this state. It may be then going to the next state and so on and so forth before, and I quote, a national level uniform civil code be put in place. This was a very wise decision, a very reasoned decision, and a very mature decision by the union government. So, we are going to study what are the changes and what are the various or new things that have been introduced by the Uniform Civil Code. So, on the screen, you will see this is the actual draft of the Uniform Civil Code as has been placed before the State Legislative Assembly. It says Uniform Civil Code, Uttarakhand 2024, fostering equality through uniformity, which is a very important tagline because uniformity will bring about equality, which actually suggests that because there were several personal laws in the past which are in force already, we have seen many cases in which these personal laws are discriminatory in nature. In other words, it is going against the spirit of equality, which is a part of basic structure doctrine of the Constitution of India. So let's understand each of this and we'll go one by one. At least look at the top salient features of this Uniform Civil Code. Of course, as I said, this is still at proposal stage. We still do not know what the State Legislative Assembly is going to pass, what are going to be the different amendments, what is the final law that is going to be in place. But more or less, let's study the salient features one by one. Looking at that as number one. So I'll read the part of the law. This is the screenshot of the law one, which is highlighted in yellow. And then I will try and understand as a student of law, as a lawyer, what might be the implications from these recommendations. Let's see. So the first one says prohibition on dissolution of marriage. No marriage, it says no marriage solemnized or contracted before or after the commencement of this code shall be dissolved in any manner except in accordance with the provisions of this part, notwithstanding any usage, custom, tradition, personal law, or of any party to the marriage or any enactment to the contrary. Don't worry, I'll try and make sense out of it in the simplest way possible for everyone's advantage. The word, let's concentrate on the third line from the top. It says that no marriage shall be dissolved in any manner except in accordance with the provisions of this part. So, what it says essentially is that hereinafter, if there is a marriage which has happened, which has been done, contracted before or after the commencement of this code, if you want to take a divorce, so to say, you want to nullify the marriage, then it can be done only by the way and the measures which have been given in this law. Notwithstanding, that means despite any usage, any custom, any method of divorce, any method of talaq, whatever you want to say, by any which way that you were knowing that there were many ways that were present in which the marriage that was contracted or solemnized could be dissolved in the past is hereinafter nullified. It's no longer possible. Or it also says that even if there was a law in place, even if there was a legislation in place, I'm not talking only about customs and traditions and personal laws, even if there was any other statute in place, and that is contrary to this present law, which is at discussion, which we are discussing, then even that is null and void, which raises certain question marks. That means all the personal laws and everything, the ways, the very different ways, and I'm not even trying to enumerate all of them, are they out of the window already? At least this is what, in my limited understanding of the law, this one paragraph, this one section tells us. So, this is number one. Big news, very, very important change. Let's look at the second one. It says legitimacy of children of void and voidable marriage. Notwithstanding that a marriage has been declared null and void, any child of such marriage shall be deemed to be legitimate. I am very, very impressed by this piece of law. Although this is also in the line with the various laws that are already into place, because child welfare, the justice with relationship to children is something that we have been always very serious about, be that as a part of Article 15 subclause 3, because we make special provisions for women and children. Also, although we look at directive principles of state policy, Article 39 subclause F, we have to protect children from any kind of material abandonment or physical or emotional abandonment or social stigmas and so on and so forth. So in that case, this law is also forward looking. that even if a marriage is declared null and void for n number of reasons, right, which of course we'll discuss in the subsequent parts in this same video, the child of such marriage will not have the social stigma of being called as illegitimate. He will be deemed as legitimate. Of course, we are talking about here succession rights and inheritance rights, which will obviously follow suit. So, in that way, very wise law, very maturely done, and in the line of social welfare and justice, at least insofar as children are concerned. Oh, and this is something that everybody is talking about. The social media is a buzz. The Twitterati is hyperactive. Everyone is talking about live-in relationship. So, what does this law do? This law actually, first of all, deals with the definition of the word live-in relationship. It says, and I quote, it says, live-in relationship means a relationship between a man and a woman who will be hereinafter referred to as partners, who cohabit in a shared household, who live together in a shared household, and through a relationship in the nature of marriage, provided that such relation is not prohibited under part 3. So now the part here is they have also now announced, or rather defined, that what is a shared household. Shared household is that the partners, the man and the woman, they live under one roof in a rented accommodation or in a house which is joint ownership, or by any one of them or any other accommodation. They are taking the concept of live-in relationship in a very strong foreword of the definition of law. Now, there is another very important concept, and for which we will have to come back to the slide. So, for the time being, remember that there is a live-in relationship now as a part of formal law, which is a part of Uniform Civil Code. They have described who will be live-in partners, what is the nature, who are living in shared household. Now, what is the second part? If I look at it, there are pages, paragraphs, one after another, which is dealt by in part 3 of this draft, which is actually explaining what is a live-in relationship, if there are living partners, if there are partners who are in live-in relationship, what kind of joint statements they have to make. They have made it obligatory that they have to submit that they are in live-in relationship, and this submission, this statement has been to be made to a registrar. This registrar will accept this registration. They will get to know where are these live-in partners remaining, what are their names, what are their identifications, for how long have been there into relationship. So this is very important. I say it's very difficult for me not to accept that the times have changed. This is a very forward-looking legislation. We must congratulate the government of Uttarakhand that they've actually finally brought about a formalization of this relationship, which is the truth of the society today. They also say in this law, the law also provides that if there is a child out of this live-in relationship, that child will be legitimate. So, amazing entry we are into a very different zone. We are in uncharted waters. We are for the first time discussing about live-in relationship to that extent. Also, please remember, the Honorable Supreme Court in several past judgments has already said that live-in relationship is practically almost as an aspect of marriage. So they have the similar rights like conjugal rights of a man and a woman who are already entered into a matrimonial relationship. It says a very important say anybody who is into live-in relationship will also have to make a joint signed statement, and it is not advisory in nature, my friends, that this joint statement has to be done or this registration has to be done to the registrar. This is not an advice only. This has the power of the law. In other words, this registration has to be made within a period of 1 month from date of entering into such a relationship. And if these partners are not able to do this, or they fail to do this within 1 month, 1 month from the date of entering into relationship, it is a punishable offense. They can be sent to jail for a period of 3 months, or with fine, which is about 10,000, maximum of 10,000, or with both. My friends, this has never happened. We have never read such a law, and this is why it's all around the news. So, the point here is live in relationships have now been formalized, a legal implication has been made, and an onus has been put upon these partners that they will abide by the law, else they will face punishment. This is new and this is groundbreaking. I am sure all of you will accept this. If you read the next paragraph, which I have culled out of this legislation, it says conditions for marriage. A marriage may be solemnized, contracted between a man and a woman if the following conditions are fulfilled, namely, and I read subclause 1. It says neither party has a spouse living at the time of marriage. This is the point number 1 for section 4, subclause 1. And the next one which draws my attention is section 4, subclause 3. It says the man has completed the age of 21 years and the woman the age of 18 years. Now, why would number 1 attract my attention? In a way, it is saying that there shall be no polygamy in the future. Yes, because it says neither party has a spouse living at the time of the marriage. That means neither of the partners will already have a marital partner who's alive, which automatically means that we are talking about monogamy. There cannot be polygamy, there cannot be multiple marital partners. That automatically takes me to point number 3. It says the man has completed the age of 21 years and the woman the age of 18 years. This is uniform civil code in the truest sense, because for all other religions also, even if there is different age groups in which legally marriage could have taken place, no longer is it the case in case of Uttarakhand's uniform civil code, because it says everyone will follow the same age brackets. Man will have to be 21 years, woman will have to be 18 years. In other words, everyone falls down to the same. These are the same age brackets in which Hindu Marriage Act takes place. So we are having a uniform personal law. In the truest sense, as the name says, so we have many changes. Also, they have ensured, look at the last paragraph, last section, last subsection, it says, for the removal of doubts, the Uttarakhand Compulsory Registration of Marriage Act is hereby repealed. All the previous laws related to all personal issues, when I say personal issues, marriage, divorce, succession, all of them are gone. They have been repealed, and hence the law which would be in force, and undoubtedly after passing of this by the State Legislative Assembly and the receiving of the Governor's assent, this would be the only law in place. Amazing piece of legislation, groundbreaking to say the least, but like every other law, there are certain errors, at least as a lawyer, which I notice. So if I look at chapter 3, if I read section 21, restitution of conjugal rights. When either the husband or the wife has without reasonable excuse withdrawn from the society or the other, the aggrieved party may apply by the petition to the court for the restitution of conjugal rights and the court, and so on and so forth. To cut a long story short, the discussion is around section 9 in the Hindu Marriage Act. We had considerable discussions with relationship to can the court force anyone who does not want to live as a marital partner to anyone else to cohabit with that person against his choice, is the moot question here. It is the bottom line over here. I don't understand, and at least for the time being, I'm not very clear that what does this, or why does restitution of conjugal rights have to find a place in a forward-looking legislation. This is something that many countries have actually thrown out of the window. Why put it in a forward-looking legislation now? Also important is, if you look at the other side of the screen, words such as full blood, half blood, uterine blood, it is so very yesterday. These are the kinds of words that usually should not have found a place in a modern legislation. And I don't know whether they will leave it as it is, or during the process of deliberation in this legislative assemblies, they'll have to cull it out. And the last one, which I noticed, was on the failure of the parties to approach the sub register for registration of marriage, divorce, or nullity, as the case may be, or being required to do neuters. Such person shall be punishable with a fine not exceeding 25,000 rupees. I consider this pretty absurd in the nature. I mean, in very, very local terms, I would say, if you are in a live-in relationship, and hear me out, if you are in a live-in relationship and you do not register yourself, then you have a far bigger punishment, that is a jail term of as much as 3 months and a fine also. While if you are in a marital relationship and you do not register, it is merely a monetary fine, which kind of raises question marks why the two different set of laws. Of course, live-in relationship is another element, and marital relationship is any other relationship. You are actually talking more about live-in relationship, and you are discussing more about live-in relationship. You are more bothered in terms of legal language in terms of live-in relationship as compared to marriage. It's kind of surprising. It raises eyebrows, and these are the future challenges which the Uttarakhand bill will have to face. Of course, it will have to face many other challenges also. It could be legal also, apart from the various political and the practical challenges. Having said so, congratulations. If the government of Uttarakhand can hear us, you've done a commendable job. At least it is a big step, and it has been a very, very much awaited step in terms of enforcement of the Uniform Civil Code. In this limited period of time, I think I've been able to explain quite of some salient features. If you want to know more, please feel free to become a part of our Unacademy team, Team Sid Live. There are many, many courses waiting for you: prelims, GS course, prelims crash course, CSAT course, mains course, pre-test series, mains test series. And also, please remember, if you are taking the subscription from till 8th of February and you use my code SIDLIVE, SIDLIVE, you stand a chance to save as much as 40,000 rupees on your subscription, which is a 50% flat off. I hope you have enjoyed this, and if you've enjoyed this, kindly like, share, and subscribe.
In the words of Unacademy, let's crack it. Until next time, God bless, thank you, and Jai Hind.